So we are next ready for Stonegate Motorplaza Condominium versus HP Motorplaza LLC. Come on up. This one.
Just a moment.
Oh, no. We always have stuff, lots of stuff. He walked outside. He's not in here right now.
Not quite. Not quite.
He's here. I did. Ready? Mr. Booth, Ms. Baker, both ready? Ready to go? Okay, I've already had you enter your appearances, so you don't need to do that again.
Okay.
Okay, Mr. Booth, you wanted 3
minutes for rebuttal.
I have to tell you, this case introduced me to something I had no idea existed. I had no idea there was such a thing.
Me too.
Garage condominium. I guess
Or
I've
the-
never owned a car that would warrant such a thing.
Or
See it.
My 2015 Camry, I don't think would be in a
fit in.
good place. Okay, thank you. I'm sorry. Go ahead.
more than welcome, you're on. May it please the court. Well, we all know that as long as you have your freedom, the next use we have for the law is preservation of property rights. And real property especially hangs itself pretty high on that pole. And so here we have a situation in which there's a forfeiture or a loss of real property, the transfer of fee simple absolute without any language in either the statute or the declaration. We can play around with the idea of which trumps which, but in this case, the declaration was drafted by the people who drafted the statute, and the declaration and the statute run remarkably similar. There isn't a dissonance between the two. And that's especially true in that when we talk about the 7-year itch that we have in this situation, and where you have this deadline, the statute gives you up to 7 years. Of course, the declaration took the 7 years. So
What's that in there? Explain to me why you think that. What's the purpose of that?
I like that question because the developer gets to write the game. The developer is going to set the tone, and they're going to preserve every right and get every option, and they get to set the entire scene. So you have an empty plat, you then design the plat, and then you invite people to come to join the party, and you have these different conditions. And then what is the counter protection for the owners of condominiums and the community? Because each time you make a change in this, from going from convertible land to condominium land, or from expandable into the condominium, you have to stand before the community and file new plats, get new plans, et cetera. And in order to do that, you have to, be answerable. You lost the unilateral control. So as primacy of property ownership, as the kingpin of this property, you get to set up the scheme, but you don't get infinite control. Property law is full of, you're going to time out at something at one point or the other. And so there has to be some way in which there's some guard post on what we're going to do. The next question then comes up to what happens when these deadlines expire.
That's why we're here.
Yes. And when it comes to convertible land, it's no longer convertible. That's simply it. You had an option to convert, and you had 7 years to do it. If you didn't convert it, you're right where you were before you started the game. If you have an option to expand the property, it never was part of the condominium, and therefore you don't have a chance to, there's no claim to it, there's no interaction, there's no interplay like there is in the convertible property, but you just lost the opportunity to unilaterally toss this extra track B into the condominium. And part of the reason for that is that after you've plotted, after you've amended your declarations, and all of these steps have happened, and you've built the property, I, as a condominium owner who used to own 1/24 of the condominium, now own 1/48 of the condominium. because it grew in size. And that may or may not make a big difference because sometimes a smaller slice of a larger pie is more attractive, but at the same time, it's a smaller share of et cetera. And so, and they don't have a choice. The statute's clear in that instance that, you don't have objection to going from being a X percent to a minus X percent owner. So as you can see, being the declarant, which I think is probably the best way, you developer, declarant, you can go through a couple of D words there. Being the declarant, you get to set the tone. You're the one making the investment. And then people who come in to buy, a diligent buyer would read through everything they have. These people can't say we were promised a larger condominium, because when you read the contract, what it says is, I have the option to bring more condominiums in. It doesn't say you get an opportunity to see bigger condominiums. So if you think back to the old days when you go visit lake property and get your free toaster, you would then have these, this idea that if you got your lakefront property, I had some in-laws one time that bought that, and they were the only mobile home in a hilly area in the Ozarks. It never developed, and they just felt absolutely burnt. But they didn't have any guarantee that this scheme was going to work. You have to take your bet. These people were able to look in and see that there was a set of condominium buildings already there. So before you buy one, your neighborhood. It wasn't just open field. And so, there's that, but there's no guarantee. You can't claim, I thought I was going to be part of a 100-unit community versus the 20 units or whatever numbers are. You have what you bought. And if you read, you realize that you have the benefit and the risk, whatever it means to you, that it could be converted and more buildings could be added. There are restrictions within the declaration that say you have to have something similar. You can't put the motorsport here and a water park next door, that kind of thing. So there's no expectation that is reasonable. Yes.
We're looking at two types of land here, convertible and expandable.
Correct.
And the issue is whether both become the owners of the current condominium owners.
Correct. Ultimately, the trial court, which I wasn't going to speak too much because it's a de novo review, but the trial court found that because the expandable land was part of the plat, and part of included within the language, this expandable property is part of this declaration. Well, yes. The declaration has to say what the expandable land is, otherwise you don't have any expandable land. That's all that means. Otherwise, it's not part of the condominium. It says the condominium could be expanded. The convertible property is in a where it could be converted to condominium property, and it's within that group that's a narrower subset.
So,
Yes.
I didn't mean to interrupt you. Go ahead and finish.
But it's a narrower subset.
Okay, but so my question is are you challenging that your client lost the expandable land or the convertible land?
Oh,
Okay, that's what I thought, but I thought earlier I misunderstood you then because I didn't think you was challenging the convertible land since it's platted with the plat of the condominium, right?
it's all platted. So the plat has everything. Otherwise, it's not there. You can't have expandable land, and you can't have convertible land unless you plat it first.
So is there the 7-year window? Is that a kind of a punishment to the developer if they don't get it properly? All the land in the convertible part reverts to the current condominium owners?
No, there's no mechanism that reverts it. There's no language that reverts it. The only language that the lower court hung on to was the deemed language that during the time it's convertible land, it's deemed to be common property, and that has to do with management purposes. But the only way you become common property is through that process of amending the declaration, creating new plans, and replatting. And then once you've built, after that, that gets you in there. And then once you've built, then there's a redistribution of the common property shares. And that redistribution of common property shares is really the lockout. You cannot say that because it's just deemed to be common property for some purposes and not others, that it becomes common property because there's this architecture within the statute that you would have to just ignore to get to the fact that all of a sudden the common property changed significantly. We moved, total bill is 1.4 million, but we moved, a significant portion of that just within the common property. So you can either invent the idea that title changes, or you can read the idea that convertible property remains convertible for 7 years, and then it's not convertible anymore. What do? Well, you're a fee simple owner of this property. It's
So
part of the
which brings me
condominium
back to
plat.
what's the point of this statute?
Huh?
I mean, the statute has to, why do we have all these restrictions if after 7 years, it just goes back to the property owner, no harm, no foul? I mean, I don't see the point of the statute then.
There's 7 years worth of value there. It sets the rules of play that I own a condominium and you're going to turn around and add more condominium property to it, reduce my proportionate share, what are the respective rights? What do you have to do, developer, in order to make that more of a condominium? And in the meantime, it also regulates what the community has to say about these things. Because if you have to go back and replat and you have to go back and do new plans and get approval for those, et cetera, you still have a community watchdogging this. You could do it all without it under private contract, but then you wouldn't have any consistent, assuming we have some, because the act's been around for a while and we don't have any case law.
So is the statute to protect these condominium owners?
It's more to protect the developers. In some of the other jurisdictions cited, they're more consumer. New Hampshire was a statutory scheme that was a scheme designed to protect condominium owners. This was written by condominium developers to protect condominium developers. And so it needs to be read in that bias. Because read through what it says. It says, here's the condominium and here's all our rules and regulations and how we treat one another. And that's statutory and part of the declaration. They kind of match. Have this idea that you can, how that gets regulated within there and move forward. Does that make sense?
I mean, I understand your position.
I want to get maybe more back to, I always think of property as Merle Duncan's bundle of sticks.
Yes.
So the expandable land was not, the bundle was not commonly owned. Is that correct? The expandable.
The expandable land may have one stick in the bundle in the sense that what it has that is of interest is the developer can add it to, and the bundle of sticks that I'm talking about at the moment is the condominium, not the expandable land, because the expandable land was his. He could have walked away from the idea of expanding that condominium and done something with it the day after he wrote the
So
declaration.
complete discretion
Complete.
during that period. Okay. And then the convertible land, unless it's converted, the bundle of sticks are commonly owned.
No,
No?
there's no ownership in the convertible land by the condominium until it's converted. And that goes back to that idea of distributing the common property. You either have ownership by an individual condominium owner or ownership by the developer. And you have to have a transfer of that ownership, and that's described. But of course, there's no description of how to transfer it's otherwise not converted. And then the conversion is this walk-through process that's described 1, 2, 3, 4, 5. And until it is, it's fee simple owned by the developer.
So it's fee simple and not common.
Correct. So arguments and the record shows that the deed, the tax payments and the maintenance for the convertible land all stayed with HP.
You're at your limit before you get into your rebuttal
Okay.
time. So I'll give you a few seconds since we've asked.
I think that if
I
it
think
answered your
you-
question,
You've answered the question.
Okay, thank you. You still have your 3 minutes of rebuttal.
Good morning.
Good morning.
I am Janet Baker and I represent the Stonegate Motorplaza Condominium Association. And the first thing I'm going to do,
Oh, that's pretty classy that it does
I
that.
came ahead of time,
When you're vertically challenged, you know how to do that, right?
and we can also move this
Out of the
out of the
way.
way so I don't have to watch myself on the TV screen while I am trying to talk. In addition to myself, the Stonegate Motorplaza Condominium Association appears by its president and a member, Scott Donahue and Jerry Weideman. And Mr. Donahue is also a named plaintiff.
Got it.
You ready to start? Start my time. This appeal, as Your Honor rightly noted, is about a developer's failure to complete a condominium project within the statutory period, what the consequences are of that failure. Now, you all may know some basics about what a condominium is, but just briefly, the way a condominium works is that a developer owns land in fee simple ownership and then submits it for condominium development. At that point, the character of the land changes and it becomes one of two things. It's either units or it's common area. There is not a retention of fee simple absolute ownership. The statute is clear about that. The declaration is crystal clear about that because in various places, it defines what the common area is. And the common area, section 1.8 of the declaration, is the entire project, less the units. 1.18 of the declaration, the project is the submitted land. 1.36, the submitted land equals Exhibit A. And I'll get to more about the submitted land in a moment, but the way it works is that each individual unit owner has an undivided interest in the common area, which is of a permanent character. It is not temporal. It does not go away without amending the declaration, which is amended when the developer builds more units on the property. So if you start out, as this development did, with 12 units, everybody owned 1/12 of the common elements. If it gets built to 110 units, which is what was proposed, then each individual unit would have 1/110th interest in the common area. The declaration also says at section 10.3 that the declarant, who is the developer, the developer files the declaration and is the declarant under the declaration, that the developer does not own the common elements. So to suggest that this property after 7 years somehow magically goes back to fee simple ownership just shows a total misunderstanding of the whole concept of condominium development and what Kansas law provides. Now, the question that we have here is, what is the submitted land? Clearly, the land designated as convertible, like I said, land comes in as either units, there were 12, or common area. The declaration refers to it as common elements. It's one and the same. So it comes in units or common area. The common area can be defined as convertible, meaning this property we may bring in, or there is expandable land. I'm sorry, convertible meaning we are retaining the right to build units on this property. But until then, it stays common area. And if we don't build on it, it remains common area. And then the
So
question
there's no
is,
guarantee that this is going to be reserved for everybody as a whole. They can build garages on those units.
that's right.
On that area.
Or they can designate limited elements, which are enjoyed by, one or two, a patio for a unit. That's not really the case here because this is a garage for, nice cars and race cars. So there's not.
There are living quarters too, right?
No, it is not for residential use. However, when you go into these units, there is like a loft area for entertaining, but you're not supposed to be living in them permanently.
So there's kitchen type facilities.
There's a kitchen,
Okay.
there's a bar, there's things to enjoy, talking about cars and driving your cars. So there is a place to get together, but it's not designed for people to live there. So it's non-residential. So the submitted land, it is our contention, and this was an uncontroverted fact below. The developer did not controvert our statement of uncontroverted facts as set forth in our response to their motion for summary judgment. The developer filed for summary judgment. We filed a cross motion. The judge did not go along with their viewpoint on their facts, but they didn't controvert our facts. One of the facts that Judge Halber, excuse me,
It's hard.
Judge
I know.
Halberday, found was that the entirety of what was described as Lot 1, which is found in the record at volume 6, page 227, the entirety of Lot 1 was submitted land. On the exhibit to the declaration, the exhibit makes reference to Exhibit A as having the submitted land, and the submitted land is defined as Lot 1. That includes the whole 40 acres. That includes the whole Megillah. There's the convertible land, the expandable land, and the units, all within Lot 1. Now, it goes further to refine it after the condominium plat was filed, which was filed on the same day as the declaration. The developer intended to continue to include all of Lot 1. And Lot 1 included the expandable land. So we are contending, and Judge Haber agreed, that the expandable land really was just like the convertible land because it was included within the submitted land. So the developer made the choice to submit the entirety of the property to the Condominium Act. Now, the law does not provide for a change in character of the undeveloped land to go back and be fee simple absolute, owned by the developer again. We don't read into these statutes that which is not there. The statute is clear, and the deemed argument is not temporal, and it really doesn't matter because if you look at the entire context of the law and of the declaration, it's common area until it is developed. And if the legislature had meant to have such a thing as a withdrawable land condominium, could have had one. There are states that have those, but not this statute. That is not a remedy in this statute. The consequence of the failure to develop is that the property remains common area owned by all of the association members in common, not the association. You'll see all these references to land grab by the association and forfeiting land to the association. It's not owned by the association. Common area is owned by everybody, every member of the association in common. And it goes.
So is it your position, going back to what was the point of this statute? Is the point to protect those people that buy in, to protect their interests if the developer doesn't follow through with the promises that are made at the beginning?
Absolutely. As Judge Haber noted, there's a shelf life to these developments. There has to be a hard stop because otherwise, does the developer retain an infinite right to develop the property? Or as it was said, you can't build a water park on it, but if it goes back to fee simple absolute, what's to protect the developer from selling it to somebody who wants to put a water on it?
And not so much what's to protect the developer, but what's to protect those condominium
Right.
owners,
That's what I meant. What's to protect the condominium owners? Thank you. For having a totally unrelated use built on fee simple absolute property. That is not a condominium. You can have certain developments that have attributes of a condominium, but not be a condominium, because for a condominium, you have to have the element of common ownership. That's what makes a condominium a condominium. As far as going further on the purpose of the 7 years, I don't know. who wrote this statute, and I don't know whether council knows. I do know that it was based on the Virginia law. There's very little Kansas legislative history, but the Virginia law has a bunch. And that was the predicate for the Uniform Condominium Act, which came 2 years after the Kansas Act. And consumer protection was an undercurrent. These unit owners buying in have to know that at some point development is going to be completed or the property will remain under their control as common area. It also protects the developer because the developer has time. The developer doesn't have to plat the whole thing already done with, however many units that the developer was going to put in this condominium. So the concept of phasing came about in what's called the second generation condominium statutes. And so the Uniform Condominium Act incorporates that, as well as other states that we have cited to in our briefing, and as well as the amicus brief cites to those and the underlying philosophy. And there is a balance between the right of the developer to have time to build units and the rights of the property owners to know that at some point we're going to be done. The developer meant to include the entirety of Lot 1. You can look at the marketing materials that were handed out. They're in volume 6, page 227. It shows the whole lot as being full.
Explain to me this position that expandable land, though, requires certain things be done before it becomes part of this whole. But is its appearance on the map enough? Or are there other requirements that need to be met on expandable land?
Our contention, expandable land, it's the plat is not as significant as the definition in the declaration.
Right.
And our contention is the exhibit
It says Lot 1.
declaration, Lot 1, included the expandable land. Expandable land doesn't even have to be owned by the developer to be designated as expandable land. But the way that they did it and the way that they chose to do it, they put all of Lot 1 in the definition.
Okay,
Expandable.
you just threw me for a loop here. Expandable land doesn't have to be owned by the developer?
Not initially. Be subject to acquisition, maybe a contract on it or something, but because.
Well, then how can they pledge it if they don't own it?
Right.
Because it's an option.
But an option for what?
To acquire and then develop it. So, I mean, if, and I'm not going to suggest that I know all about how, when it's done properly, but when it's done properly, the expandable land can be acquired and incorporated within the condominium in 7 years. So it doesn't have to, am I saying that that's normal? I don't know. I mean, the amicus pointed that out, that it doesn't have to be owned by the developer to be designated for some time future development. But that's not what we contend was done here and not what Judge Halber found. He found Lot 1, the entirety of it, which was owned by the developer, to be submitted for condominium development.
Okay.
Did that answer your question? I know it doesn't connect that they wouldn't own it, but they would identify it. But they could have a contract on it, or they could have a related entity that owns it with the ability to bring the property in.
But you're saying that the developer is then pledging somebody else's land to be a part of the condominium property.
But not currently. Not in the,
That would take effect in 7 years.
if they're going to do it, it has to happen within 7 years. 7 years to expand land in, and 7 years to convert land into units on the convertible land. But what Judge Halber found, and again, it was an uncontroverted fact that the entirety of Lot 1 was submitted land. Submitted land is either common area or it's units. One of the two things. So
I just want to let you know, you have about 2 minutes left, just to give you a warning.
well, I can sum it up. Common area, again, is owned by all the unit owners in common. It has a permanent character. It's not temporal. It doesn't disappear after 7 years. is then you don't have a condominium. So the association is asking you to uphold the decision of the district court, find that the developer's right to build additional units on any of the land is terminated because of the expiration of 7 years, and confirm that the undeveloped common area, lots 1, 4, 5, and tract B remain common area of the association. And I would like to quote Judge Harbor.
Tract B is that expandable land. piece,
Yes.
Right.
And I would like to quote Judge Harbor. He said, excuse me, "We don't need to overly complicate the issues. Convertible and expandable land are common area here. The statute is clearly applied to reach that result." So with this deemed, and that I think is just thrown out to obfuscate the issues. The land was submitted by the developer.
Well, it is curious, the use of the term deemed. I mean, that causes me pause.
You look at every other statute, the result is the same.
Whether
With the
it's
word
or
deemed.
not, right.
And deemed means is, by their very own cases, deemed means is. And it doesn't, the point is, it's a condominium. It doesn't go away. The land doesn't go back to the developer in the context of condominium ownership. And every other court that has made a determination that the common area remains common area at the expiration of 7 years has confirmed that the land is common area, owned by all the association members in common. And there's one example, well, there's several examples in the cases that were cited about the developer's claims and what the result was at the end of whatever the time period was. In one, it involved a convertible building that the developer didn't fully convert. And the units that were already in the building were deemed to be common area of the association. So from an equitable standpoint, the developer had the choice. The developer did not have to plat this land and file a declaration putting all this land in a condominium project. And by making the
But
choice,
the idea would be you do that to get purchasers,
yes,
to be making guarantees that purchasers feel they could rely on in making the purchase, so they don't have the trailer on the lake,
exactly.
nothing around it.
So they know when they buy into a condominium project that the condominium project will be completed within a period of time. And if it is not, the undeveloped property remains common area for the association members to decide its future. Any other questions?
I don't.
Thank you very much.
Okay, thank you.
Mr. Booth, let's clear some of this stuff up from your standpoint.
I'll tell you all what to think.
Okay, thank you. We've never had a problem with that in the past.
Well, first of all, when we find that expandable land may not even be owned by anybody that can convey it, that throws away the idea that submitted land means something of a conveyance of importance part of the condominium, because submitted land by 583115C includes expandable, submitted, convertible, expandable, and the condominium property. So we know that breaks. The idea that it's submitted is simply the plat. And plat is not ownership. Plat is planning of what you want to do. And it becomes an exhibit in a contract that says what you're going to do. And that contract sold people a completed condominium that was expandable and convertible to more. So you get, you know, if you want to buy a 6-pack or you want to buy a case, they bought a 6-pack. They didn't know where they're going to get a case later. The steps to make either one of the two convertible are very, very important. And we go back to that. You have to have a new declaration, you have to have floor plans, and you have to have a plat in order to move the status of this property from one place to the other. And as I said before, that involves an interplay.
Expandable to convertible.
Both expandable and convertible, you have to do declaration, floor plans, and plat before they can be moved from one category to the other. That is the that's the duty that the declarant has to the condominium and to the community to not run amok. And they have 7 years in which to do that. And then you look at the convertible land, it says you have 7 years in which you can convert. There's no other way to read that if you realize that you have to do these steps in order to convert it, is that you've lost your right to convert. This person owns property that could have appreciable value because of the existence of the condo that could increase and continue to build things and have a market right there. And they're going to lose that right, but that's all they lose. They don't lose anything else. They lose the right.
Correct, as Ms. Baker says, that the owner of fee simple title could then do whatever they wanted to do with that undeveloped common land. So I could sell it for you could sell it for a quick trip.
They
Nothing against quick.
First of all, it's not, it hasn't become, it's deemed common land, and it is not true that deemed always means the same as not deemed. You add a qualifier to a word, and if you're deemed common versus it is common, that's very different.
But what I think I hear you saying is that, so after 7 years, you haven't developed it, then all bets are off, and you have fee simple of that land,
right,
without any restrictions.
Restrictions would be, of course, you got to deal with replatting whatever the plat is, and replan and work with the community. And so, can you make a quick trip? You can't put a quick trip in the middle of a housing community. You can't put the Kansas City Chiefs.
Went to the city and got.
Well, if you do, then there's checks and balances.
In the realm of possibility.
Yeah. If you follow the checks and balances, yes. Just like I could put something interesting in my backyard.
Statute give the condominium owners at all.
Condominium owners. It gives them the protection of exactly what they bought into in the contract, and the contract says you buy this, the condominium that is expandable, convertible. Sorry, is expand. She did that on purpose.
She did. I'm sure.
It is. You have a clear description of what you own and what the rights are and the respective interplay within the declaration. You bought into that, and you get fair warning that this could be expanded. And if it's expanded, or not, I'm sorry, converted or expanded, really, I guess both fit in this analogy, you're going to have to follow the same rules of the declaration or how the declaration is amended. And you can't amend, and you got to go through the amendment process to amend it in any direction. So the condominium owners have a stake in the iron if they're doing that. But to say that you all of a sudden completely lose your property rights simply because you didn't do these steps and didn't, so let's say you're partway through building and you've got a few $1 million involved in construction that's pending, and whatever happens, another COVID pandemic or something like that, beyond your reason, a blind 7 year where you lose your entire property would have an incredible chilling effect on anybody who wants to develop property. And it wouldn't be a decision that anybody would be willing to make. So the statute would just basically put you in a position where you're either going to.
The developer didn't have to do that here. He could have built garage condominium or these fancy garage things,
right,
and sold them to people unrelated to a condominium project, right?
Correct.
Okay.
A subdivision, just like where we all live.
So there are choices made.
Correct.
Right. And the choice was to do this as a condominium. And when doing it as condominium, there are also risks.
And one of those risks would be that you're beginning to lose choices, like your ability to manipulate your own land after 7 years, because the people that are your neighbors haven't. Now, what happens next? And it is the facts that they had already started developing this expandable land. Well, if you want to continue to develop it, you got to come back to the condominium association and negotiate, because the negotiations happened when they bought it. 7 years is over. Now we have a new bite at the apple, and you have people on both sides of the plate to negotiate. It would be in this developer's best interest to continue on with the development that was his idea, and two, this demonstrated the success it had.
So
But-
there's no evidence, and I'm sorry, this is going way over your time, but there's no evidence that this missing the 7-year deadline was some sort of just inadvertent mistake.
There's nothing to record about that
All right,
I did want to ask.
because it's really not relevant.
right.
We know that they missed the 7 years.
It's gone, right? Okay.
We've talked a lot about the statute, which of course we should, but the declaration of garage condominium for Stonegate Motorplaza, did the condominium owners, those who purchase condominiums, take that property subject to this?
Yes,
So this really controls the terms.
yes.
Now, we may interpret it the way you suggest or not, but this really controls what they own.
Correct.
Okay.
Four corners of that contract. And it is the controlling piece because the statute, if anything, the drafters of the declaration would not have gone outside of the statute. So if there's anything in the declaration, it's narrower than the statute and it's a contract. So in many ways, this is, in more ways than not, this is the contract case of the declaration.
But to find the legal effect of submitted land or the other terms, expandable, convertible, we would look to the declaration.
Which, yes, but of course, the declaration matches the statute.
Well, it's a lot of pages. We'll have to, yeah, we'll have to see, but
In the sense of the key elements that you have 7 years, and this is what you have to do. What the declaration does is interpret the statute by taking the statutory references from 311, 3115B, and those things, and put them all together and say, this is the lockstep that has to happen in order for the developer to intrude on your condominium area that you bought, which was the first thing they bought.
I guess the developer promoted this as a 40-acre tract that included the current buildings, expandable and convertible land. And so the people that bought into the condominiums thought they were buying into a 40-acre development. Is that the way it was presented?
I'm not sure that's clear in the record, one. And two, it doesn't matter because what they bought was the declaration and the contract. I bought a Triumph Spitfire when I was about 24 years old, and it had a lovely car saleswoman, and she wound up not coming with it. You can have all your dreams you want, but you get what's in the contract.
No, I understand that. But the question I keep going back to is the developer promoted all of this land to be part of a condominium. But now you're saying that they never gave up possession of tract B and tract A,
Right.
the expandable and convertible land. And so it reverts back to them after 7 years, then they're free to do whatever they want with that land.
Yeah.
And it could be contrary to the interests of the condominium owners thinking that it was going to be part of their whole property.
Problem is, if they thought that, they didn't read the contracts they signed and what they actually,
I'm not, but isn't that
That's
the way
not
it
a
was
claim.
presented?
pardon?
Isn't that the way it was advertised and presented to the purchasers?
That's
And
what they said.
that's what Ms. Baker said.
Yeah, I heard her say that. But what I'm saying is,
I'm glad you agree. I heard it right.
always a good point to make. What I'm saying is, if you buy into a subdivision and they're talking about all the things that are coming, including the Walmart that's being planned down the street and all this stuff, that may excite you that the community pool is going to be built here, or now with the Kansas City Chiefs, wherever they're landing, et cetera. But that may excite you for the investment opportunity and what the dream is, but you're looking at the deed that you have for 1, 2, 3, 4 Mockingbird Lane that you're buying, regardless of what it is, and look out the window and see what you got, because unless you read your homes association, you may have a purple house next to you, or anything else. And so you have to read what you have, and we're all lawyers and know it's the contract that controls. It doesn't matter if these people believed that the developer's dream was their dream too, and that they were buying dreams, promises instead of dreams. And this is dreams that we're talking about.
I'm not talking about dreams. I'm talking about the project was contained 40 acres of condominium buildings. And now, under your theory, the owner of tract A and B can take it back in fee simple and do something else with it.
It didn't contain 40 acres of condominium buildings. It said there's 40 acres in which we could do additions. And some of that included some of that acreage isn't part of the deal at all, tract B. And some of that could be converted. And if you're going to convert it, you have to convert into similar things that we have now. But it doesn't say it will be converted. It says it leaves that completely to the developer. And it doesn't say that they will do those condominium buildings. They would have to do something similar. So they could have built something within the compliance of the architecture that could have been a community center, a party house. They could have put, or you know, literally a mechanic's garage could have gone in there. You know, a car parts collection. You know, all kinds of things. So that could have been left to the dreams. Just like each one of the people who own their condominium, all of a sudden could whatever the use restrictions are, whatever's within that use restriction, they could be doing that too. You know, they could have a little neon sign out front and Beetlejuice on the sign. And so they, you know, whatever, people have their freedoms. The declaration dialed that in and said this, like we heard that you couldn't take it as a residence and sleep there, eat, sleep, and drink there. That's where it was. You know, that was what controlled what you could and couldn't do. And here we have, you're buying this piece of you're buying a condo. And oh, by the way, at the developer's choice, they can expand it. And at the developer's choice, they can convert some of the property they have. And the convertible property, in the meantime, is used as common property. That's the deemed issue. In the Holly case that's quoted within the other case, it doesn't say, no, always we use deemed as the same as not deemed. It says that the developer has those choices, and I don't get a vote. There's nothing in in that declaration that says, I'm going to convert the property. What do you think I ought to do with it? I'm going to convert the property. I'm going to submit the plans. That's the closest to a question. You get to say what you're going to do, and the community, the city or the county can say no, and you know, for whatever reason. So you play within the borders of what that is. And the declaration also holds him to common issues. You couldn't go to a completely different architectural style.
Yeah.
You had your question answered. We
long
let you
ago.
go way
Is
on.
it
So,
possible to make 1 minute in response?
you know, we did give him an awful lot of time. So yeah, I'll give you 1 minute, Ms. Baker. Go ahead.
With
Just
my 1
very
minute,
quickly.
yes, with my 1 minute, I just want to emphasize the declaration is a contract. Absolutely. The declaration said that fee simple absolute property owned by the developer was going to come into this condominium project. And when it came in, it was common area. It was not fee simple. It comes in as common area or units. It does not continue to be owned by the declarant. It is not owned by the association. It is owned by the members. And there is no transfer back, you know, automatically to fee simple ownership. It ceased being fee simple ownership when the declaration document was filed and the property was submitted to a condominium project.
Thank you.
Thanks.
I could have guessed that was yours. Okay, thank you both. Yeah, thank you both very, very much. Again, just like the last case, we have two very talented, thorough attorneys here. Your briefing is wonderful. Your arguments really give us a lot to talk about. So thank you very much. We'll take the matter under advisement and issue a decision as soon as we possibly can.
Thank you.
Pleasure to do it again.